Welcome to Guardianship, Supported Decision-Making, and Advanced Directives. My name is Nicole Pagano, and I'm the Director of Family Support Services here at ADAPT Community Network. ADAPT Community Network is the leading provider of support and services to children, teens, and adults with developmental disabilities across New York City. Today's session is sponsored by the Cuddy Law Firm. The Cuddy Law Firm provides comprehensive legal services to families of loved ones with special needs. In this session, we will discuss the intricacies of navigating special needs planning, meeting the health, legal, and financial needs of children and youth with disabilities. It is my pleasure to introduce our presenters, Adrian Arcantaki, Vice President and Managing Attorney at Cuddy Law Firm, and Catherine Aquino Melendez, Attorney at Cuddy Law Firm. We hope you enjoy the webinar and take away some useful information for you and your family. Please don't forget to fill out our survey on the main page. Thank you so much.
Hello, my name is Catherine Aquino Melendez. I'm an attorney at the Cuddy Law Firm's New York Valhalla location. And just to let you know, Cuddy Law Firm also has offices in Texas, Ohio, Pennsylvania, North Carolina. And we litigate special education matters, but also assist with special needs planning and guardianships. Today, we'll be talking to you about guardianships and the alternatives for individuals with disabilities in New York State. One thing I want to touch on before we get to guardianship is advance directives. Advance directives are documents that you execute, and those include a power of attorney along with a gift writer, a healthcare proxy, a HIPAA release, disposition of remains, and a living will. Now, two of the most important documents that I've mentioned are both the power of attorney and the healthcare proxy. The power of attorney allows for you to appoint an agent to make decisions for you regarding business transactions, purchases, bank transactions, all sorts of businessy transactions. A healthcare proxy allows you to appoint a healthcare agent to make health and life decisions for the individual. These are very important, especially during the pandemic that we're currently living in. These two documents are critical for every adult to have, as long as they have the capacity to execute these documents. And I emphasize that because this is an alternative to a guardianship, right? If your adult child has the capacity to understand what they're signing or executing, for example, a power of attorney, a healthcare proxy, a HIPAA release that allows for the agents to access medical information, disposition of remains, what to be done with how to dispose of your remains after you're no longer on this earth, a living will, if you want to be artificially on an artificial respirator, or artificial nutrition in the hospital if you're in an medically induced coma. These are all things that if the adult child understands, even in the simplest terms, what they're signing, they can execute these documents. But this would not allow you to then apply for a guardianship of that individual. This would allow for you to, ideally, if they choose to appoint you as their agent, to continue making life and health decisions for them. They have to be of 18 years or older, because that's the emancipation age in the state of New York. And that's when you no longer really have authority to make these decisions for the individual. Okay? And so, like I said, not only does your adult child with capacity over the age of 18 need these documents if they have capacity, right? But you yourself should have these documents in place. Very important, and very important because of the circumstances that we're in currently, right? Let's say, for example, you find yourself in the hospital and you need your agent to act on your behalf, or your healthcare agent. These documents will allow for that to happen. Something else that's, you know, starting to be discussed a lot more as an alternative to guardianship is the supported decision making. And what supported decision making is, it allows for the individual with a disability to create a team of people that he or she trusts in order to make supported life decisions for themselves. This is not authorized by law in New York State. However, if you go to the website supporteddecisionmaking.org, you can see there's various court orders denying guardianship petitions simply because this exists, right? And it's, again, like I said, it's not authorized by law, but it's something that a lot of judges are considering and saying, you know what, maybe that individual has a lot more capacity than the proposed guardians think, and they should just, rely on the supported decision making. This is not appropriate for everyone, at least in my opinion, right? Because some individuals can't even speak. Therefore, how is a team going to support them? But again, if you want some more information and to see, the most recent court orders, you can always visit the website. Now I'm going to jump into the guardianships in New York State. There's Article 81 and a 17A. I'm just going to touch briefly on an Article 81 guardianship. And this is done in Supreme Court, so it's a lot costlier. You definitely need to be represented by counsel. And it authorizes the court to appoint a guardian to manage the personal and or financial affairs of a person who cannot manage them himself or herself. Not all Article 81 guardians in New York have the same powers, right? Because the judge may say, proposed guardian number 1, you will handle the individual's financials. Proposed guardian number 2, you will handle the individual's life, right? And health decisions. So again, the duties may vary. 17A guardianship is a plenary guardianship where you petition the surrogate court asking for legal authority to remain guardian of your adult child, or it could be, your grandchild, your nephew, niece, your neighbor with disabilities, even once he or she has reached the age of 18. This guardianship is done in surrogate court, and the clerks at the court are very helpful. In fact, sometimes they like you more than they like me. You don't need an attorney for these types of guardianships. We usually recommend that if it's going to be a contested Article 17A guardianship, then you should seek legal counsel. If there's a little bit more of, complexity to this, you should seek the assistance of an attorney that has an understanding of these types of guardianships. If it's a very simple proceeding guardianship petition, you can do it on your own. The materials are on the website. I'll go through the process, and you can always contact the clerks at the office. Now, I'll tell you, during the beginning of the pandemic, the guardianship matters were not being heard unless under the executive order that Governor Cuomo signed in April of 2020, if you were in the medical field or at risk of being infected with COVID-19, then you could be heard at court. But most of the proceedings were put on pause unless it was, extremely essential to be heard. The good news is that these hearings are now starting to be calendared on the judge's docket and calendar and being heard. So I know that in October, I will be attending a few of the guardianship proceedings that I have on my, docket. in Westchester Surrogate Court, because those hearings are starting to be heard. Some of the courts outside of, the suburbs, for example, like New York State, they're moving a little slower. They have less staff, but again, New York City opened later than Westchester did once the 4 phases went through. So again, contact your court if you're doing this by yourself. Be patient. The clerks are extremely helpful, but they are sometimes limited, have limited schedules now with COVID and working remotely, etc. So now, who needs a guardianship, right? Someone with an intellectual or developmental disability who, because of his or her disability, is incapable of managing their own affairs. There's guardianship of the person and or of the property. So you can petition for both the person and property, or just the person. The person is to make decisions for their health, education, maybe apply for, open a bank, some government benefits, potentially. The guardian of the property makes many decisions, right? You can go to the bank and open a bank account on behalf of that individual, maybe for government benefits to be put into. So again, it differentiates. Where do you go for guardianship? Like I mentioned earlier, you go to the surrogate court in the county where you, the proposed guardian, and or parent, right? Because it doesn't have to be the parent petitioning all the time. I said grandparents, neighbor, right? Or your niece, your uncle. So either where the proposed guardian or parent lives, or the child with a disability. And to apply for guardianship, you have to complete a few documents. There's the physician and psychologist affidavits, aside from the petition that the proposed guardian completes, consents and waivers, affidavits, and OCFS form. The physician and psychologist affidavit is a form that either one completes and usually includes some sort of reference to evaluations that they've conducted or documentation they've reviewed. Make sure that those documents referred on the affidavit are included in your packet, your guardianship packet, right? Because sometimes the courts will reach out to you and this will slow down the process if you don't have all the documentation referenced in these affidavits, right? They'll want you to submit that documentation. So keep that in mind. Make sure the doctor has seen your child within the last 6 months or a time frame indicated by the surrogate court. Sometimes the surrogate court will specify by, when the last visit with that doctor had to have been before that doctor completed that affidavit. Usually though, make sure it happens within the last 6 months and, submit this documentation in a timely manner, because if you get that doctor affidavit completed, let's say, in July of this year, 2020, but you don't submit it to the court until next summer because life happened, then that may be an issue because it might just be a little too outdated for the court, even if the doctor saw, the individual on a specific July 30th, and you're filing in June. But again, it may just be a little bit outdated. So keep that in mind. Make sure that each doctor answers every single question. There's so many times that we receive these affidavits and there'll be something not checked off, right? A simple check mark they may have skipped over, and that needs to be completed. Make sure that at least one doctor references recent psychological testing, right? So if you're thinking about guardianship post-graduation, right, transition from school to adulthood, consider using those psychological evals from the school district if you have a good one. If you have independent evaluations, that's great too. If you simply, contact your child's or the proposed respondent or ward, right, the person you're trying to seek a guardianship over, you contact their psychologist or physician, then they can also conduct an updated evaluation or testing. Keep in mind that if you don't have both a physician and a psychologist, you can have two physicians complete the affidavit. However, one of them needs to specialize in treating individuals with intellectual disability or developmental disabilities, okay? So just keep that in mind, because I know sometimes families say, well, I don't have a psychologist. My child doesn't meet with a psychologist and I really can't locate one, but I have another doctor, another physician. That's fine, as long as one of the two physicians completing these affidavits has a specialty in treating individuals with disabilities. Now, the petition. The petition is completed by the proposed guardian. There's several questions. Some of them it's just repetitive information being asked, but it's important, again, that you complete every single one of those items, even if you indicate something as if none or not applicable, right? Because maybe it's something that doesn't apply to you. Complete every single line. The petition also asks you to list the respondent, right, or the person that you're trying to seek guardianship of, any property that they may have. It's important to be honest. Standby guardians. Who are you proposing to be a standby guardian, right? In case the proposed guardian, let's say the parent, is no longer living or incapacitated themselves, who's going to be the backup? Which doctors are you having complete the affidavit, and why you should be appointed a guardian of the individual? The affidavit of a guardian asks how long you've known the respondent. If it's your child, you can say, I've known them all my life. They're my child. And that's okay. Some parents may say, well, that's a silly question. Well, it's just, again, the court doesn't know who's seeking guardianship. So they just want to make sure that they have all the information. Educational background. There is a question about prior convictions, forfeiture of bail, and criminal charges. If you've, by chance, maybe even as a teen, had a misdemeanor on your record, you probably want to reveal that to the court and include, any sort of documentation that you can. Even if your file was cleared, everything worked out, you want to be as honest as possible with the court, because you don't want to find yourself at court, and let alone your attorney at court, without them knowing that there was some sort of criminal charge against you the day of your guardianship proceeding, and then things get a lot more complicated. So make sure to be honest with your attorney if you're working with an attorney, and or identify whatever it is on the paper. They will also ask if you have any addictions to narcotics or alcohol. Something else that's going to be asked of is 28-year address history of the proposed guardian. And that's to check that the adult has never had any filings made against them for child abuse. They'll also do background checks on children to confirm that they've never been abused, right? And there's no matters open. And that's on the OCFS form. This form usually requires for every individual living in the home to indicate, their names, full maiden names, if, different from the married name, middle initial, sex, date of birth, and the addresses where everyone has resided in the last 28 years. Try to be as specific as possible, right? Maybe you recall the street you lived on, but not, and the number of the building, for example, but not the exact apartment, try to remember. If not, it's okay, right? And you can always explain that to the court, but try to be as specific as possible whenever possible. Something that I want to touch on, because I know it's usually, a question asked when I do these presentations is, if I'm not a citizen, can I apply to be my son or daughter's guardian? And the answer is yes, you can apply for guardianship. The courts are not required to ask about your citizenship status, or either at court or on the documentation. However, there's no guarantee that the issue may not arise as a result of the OCFS form once it's processed, because this form goes to state capitol in Albany, it's reviewed, and then the communication is transferred down to the court from where it was sent from. So again, you can apply for guardianship despite your immigration status, but keep in mind that there is no guarantee as to what may happen or result if the state detects that your addresses don't match up, or there's some background to your name. Okay. Waivers. What are waivers? Waivers are basically documents that the parent who may not be applying for guardianship or an adult sibling is waiving to be served because they approve of whoever's proposed, whoever's the proposed guardian or standby. Maybe, mom is petitioning for guardianship and dad is going to be a standby. Well, there's no need, for the adult sibling to even be on this petition, and they can waive their right to be served and approve that mom be the first guardian and dad be the standby guardian. Again, it wouldn't be the ideal scheme, but it's just for examples. You can sort it however you want, right? You can do mom and adult sibling as proposed guardians, and then dad as a standby, or dad and mom as proposed guardians and adult sibling as a standby. But again, it's just for examples. For an example, some counties require standby guardians to also complete these waivers. Every county differs in the way that they handle guardianship proceedings. So you definitely want to make sure that you know the rules and the requirements for each county wherever you're filing, because if your friend filed for guardianship in Westchester County, but you live in New York City, it's going to differ, right? The guardianship proceedings and the requirements are going to differ from Westchester surrogate and New York County surrogate. So make sure that you know what's what, and you're not just relying on your friend that lives in Westchester and filed for guardianship, and you're going off of their guidance for filing in New York County. On our PowerPoint presentation, you'll see there we have included examples of the waiver of process for enunciation and consent to appointment of a guardian, and you can see the different lines questions that are asked, and it makes more sense what I was talking about. Now the consent, again, it's standby and alternatives, consent to serve. So you're consenting. The next steps, once you have all your documents completed, you have the petition, you have the doctor's affidavits with the reference material, right? Evaluations, IUPs, whatever they reference. You have your consents, your waivers, everything ready. You file the petition, any supporting documentation to the court. The court will then issue a citation, and the citation is basically a document that states when the hearing is going to take place. That citation has to be served on any interested party, right, unless they waived service, and the individual, the respondent, your child, most likely, the person that you're seeking guardianship over. You can say, well, they won't understand what I'm giving them, and that's okay. But the rules require you to serve that individual. And you'll prepare an affidavit of service and you'll file that with the court as well. You do have to send copies of everything to mental hygiene legal services, any group home, and sometimes other individuals, right? Mental hygiene legal service has a lot to say in these guardianship proceedings because these are proceedings that are going to take away all of the rights, the individual's rights. So the court appoints usually a guardian ad litem or a mental hygiene legal service attorney to represent the respondent. They'll usually interview the proposed guardians and the respondent prior to the hearing, and they'll assess if a guardianship is appropriate or not. I know that tons of my clients are always so worried and concerned when we tell them that this interview is going to take place because maybe their child has some capacity and, mental hygiene, they're afraid that they'll ask, if you want mom and dad to continue making decisions for you and that the child will say something, like, no, I can handle my own business and I do my own accounting and banking. Mental hygiene legal service has experience. They know what they're looking for. They understand that some individuals, some respondents are pretty capacitated and have the ability to communicate, but in some areas may need the help and the assistance of a guardian. So don't be afraid, about this interview. Just be honest. File an affidavit of service with the court, right? With the court. Once you've served everyone, you have to serve the court with these affidavits. And again, in our presentation, we've included an example of what a citation looks like. Now, a few more things to keep in mind is that some courts will require fingerprinting. This is not required by all courts, but some of them do require fingerprinting of the proposed guardians and sometimes even of the alternate standby guardians. The interview with mental hygiene legal service, I just mentioned, it will take place. Sometimes it'll be a mental hygiene legal service attorney. Sometimes it will be a guardian ad litem that's appointed, right? The hearing usually takes place differently, right? In every county, it's different. Westchester Surrogate Court, it's in, the courtroom. Everyone that's going in that day for a guardianship matter will sit in one room with the judge, the surrogate, and he'll call every matter up one by one, and everybody can kind of hear what's going on. In your county, I know, for example, the judge will have each family privately come into her chambers, and we'll have a conversation with the family and with me, the attorney, if represented by an attorney, and ask questions, and it's a very private experience. So every court differs, every judge is different, everyone has their own rules and ways, but again, check with the local clerk, right? Check with the clerk at the court where you're filing. And then once all is said and done, and hopefully the judge approves of your guardianship petition, you will receive a guardianship order and letters, right? These are very important and should be kept in a safe place because these will allow you to have the authority over the individual's person and or property. Something that I would like to mention is that if you have a standby guardian, you may also want to give them copies of these letters, as their name may be on these letters, and they have 180 days to petition the court if you, the guardian, is no longer capable of acting as the guardian or no longer living. And so that standby guardian can go to court and basically says to the court, I'm here, I'm ready to serve as my role standby guardian, and they'll be bumped up to your son or daughter's legal guardian. So again, lots of little pieces to an Article 17A, but I hope that the information I provided you and the examples of the documentation I've included in the presentation will be helpful. And I believe that if you have any questions, you can always ask, and ADAPT will forward those to me to answer. I wish you all well, lots of health and peace this coming fall. And for those of you who have children in school-age kids, that it's a great beginning of fall semester. And again, lots of health and well-being for all of you. Thank you.